It is 7 o'clock on September 1st, so we will call our meeting to order and we'll begin with a Pledge of Allegiance.
Flag, give me a moment here.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We will go into roll call and forgive me, it's been a little while, but I think Judy, you still have roll call for us.
I guess I do.
You will need, because it's an electronic meeting, you will need to not only state your name that you're here, but also state where you are. So if you're in Union Township, Isabella County would be fine. If you're somewhere else, just the name of the place.
Okay. Ryan Buckley,
Here, Union Township, Isabella County.
Andy Tyson,
Present, Union Township, Isabella County.
Presnell,
Here, Union Township, Isabella County.
Brandon LaBelle,
Here, Union Township, Isabella County.
and Judy Lannon here, Union Township, Isabella County.
Perfect. Thank you, Judy. With Brandon being our first alternate, we will include Brandon as a participating voting member of the board tonight, since we have a vacant seat. So moving forward, Brandon, you will be fully eligible to participate in the meeting. Thanks for joining tonight. I would look for a motion to approve tonight's agenda. Do I have a motion to approve tonight's agenda?
I'll make a motion to approve the agenda.
I have a motion by Judy. Do I have a second?
I second.
Second from Liz. Any discussion? Seeing none, all those in favor say aye.
Aye.
Any opposed? No. Okay, correspondence and board reports. Ryan, do you have anything from the Planning Commission for us?
And I was just actually pulling up the board packet from our 17th meeting here. We've had a lot of meetings since we last met with ZBA. I will say, I mean, outside of the approvals that we've had on any number of site plans and some of the conversations we've had there, we did go through a round of fairly recently here of taking a look at and recommending. I can't remember if we actually recommended approval or if it was if we had to we were holding a public meeting on it, but we had several updates and changes kind of in some of the master planning and the zoning ordinance that some language cleanup. There were a couple of more significant changes. Probably the one that is the most significant would be a change recommendation that we I would say conform to what the majority of planning commissions do now across the state of Michigan, and that is to, rather than recommending approval of special use permits, actually taking on that responsibility from the trustees and making that decision at the commission level rather than at the trustee level. Beyond that, there was a lot of kind of cleanup and some clarification on some issues that maybe have been oversights during that planning process. And so of late, I would say that some of those changes that we have recently covered would probably be the most significant thing that may be relevant to this board being conscious of. Yeah.
Okay. Other than that, I was going to comment on in your packet reminder to I guess review your expiration dates on your appointments, and then remember that we do have 2 vacant seats. So always encouraging anyone who's interested, or if you know someone who's interested, I should say, to speak out and encourage them to participate. Rodney, Peter, do you guys have anything from a staff perspective that you'd like to add at this time?
I think the only thing I'll add, first of all, if you do know somebody who would like to serve, certainly encourage them to fill out an application. The application form is on our website. We're happy to provide a copy. As Ryan mentioned, we have been doing kind of what I've referred to as a punch list set of zoning ordinance amendments to take care of some details and also pick up a few things that are new. As Ryan mentioned, but that hearing is actually scheduled for September 21st. So if anybody's interested in that, the actual set of amendments are available on our website along with the hearing notice, and certainly welcome to comment on it.
Okay, if there's no other correspondence or board reports or staff updates, I would move to item 6 on our agenda, which is approval of the minutes from our seemingly forever ago, March 3rd meeting. Those minutes were provided in tonight's packet, so hopefully everyone's had a chance to review that. If there are any questions or objections, now is the time to correct them. If there are none, I would take a motion to accept those minutes as presented.
Motion to accept the minutes as presented.
Perfect. Thank you, Liz. We have a motion to accept the minutes as presented. Do we have a second?
Support.
Support from Ryan. Any discussion or questions? If not, all those in favor of accepting the minutes as presented from the March 3rd, 2021 regular meeting, say aye.
Aye.
Aye. Any opposed? Perfect. Item 7, public comment. As a reminder, public comment is restricted to 3 minutes, and it would be for any items that are not on this agenda. There'll be a time to address those items that are on tonight's agenda at a later point, but any public comment, will open public comment at 7:07. Going once, twice, sold. No public comment. We will close public comment at 7:08 and move on to new business. First item on tonight's agenda, item A, is a variance 21-01 application for a 228 square foot floor area variance and a 1 foot maximum height variance from section 7.5C3, requirements for a detached accessory building at 5633 South Grant Road, a 2-acre agricultural district parcel in the southeast quarter of section 35. Rodney or Peter, will you give us an introduction and we'll begin?
I can just give a quick introduction. Everybody should have a copy of our report dated August 24th. As was noted, there are 2 variances here. They're both related to the same 36 by 48 foot proposed pole barn building. This project, as noted in our report, began with some decisions by the applicant in 2019. That's when he first contacted the township regarding what criteria, what standards would apply for a pole barn construction. That was at a time when we were still under our ordinance that dates back to 1991. He did get that information. We did adopt a new ordinance, which went into effect in September of 2020. And that new ordinance had some pretty substantial changes to the accessory structure standards that came out of issues that we'd had with the old ordinance and kind of punch list items related to that old ordinance. The applicant did not contact the township again about these standards until it applied for a building permit in June of 21, June of this year. But as noted in our report, had he done so prior to that, especially in 2020, when he initiated certain construction activity related to trusses, he would have learned that the ordinance had changed. And in fact, even in 2019, it was common practice for staff to let all applicants know that we were working on a new ordinance. And that there may be changes associated with that. So you have our report. In the report, we did include the criteria that apply to variances. They're listed there in the table in the black border. And there are some comments underneath each of the items. We're happy to work with you on and answer any questions you may have as we go through the process.
Thank you. At this time, we will conduct a public hearing for item PVAR 21-01. And public hearing will open at 7:11.
If it's all right, I'm going to go ahead and move the applicant over to a panelist, so you'll be able to see him. Would that be all right?
Perfect. Thank you.
Okay, I'll take care of that. Just take a moment here. All right, Michael, there's a second item, a second account listed for you. Is that somebody else that I need to bring over? Or?
That's my wife. So,
okay, all right. So you're both
yeah,
here.
joined
Okay.
on a separate, but we're trying to share the same camera. So
Okay.
Okay, so we have opened the public hearing for the variance request at 7:11. We have the applicant here. Does anyone on the board have any specific questions for the applicant before I open them up an opportunity to speak to us? Okay. Michael, if you could give us a brief understanding of your request. I won't intentionally try and cut you off, but again, we're looking for kind of a brief summary. We've all had a chance to review your information, so we'd just like a chance to hear from you briefly.
sure thing. And first off, I appreciate everybody's time and both the staff and the board and at least hearing out our situation. And I think the first point that we wanted to make was that, we really were trying to make a good faith effort to do everything we were supposed to in downloading the ordinance back in 2019 when we first started envisioning this project. And it was while doing that I learned that, there was a limitation that we couldn't build an accessory building on an empty lot. We had purchased a lot many years ago with the intention of building a pole barn. So that set me down the road of merging the two parcels after I talked to Mr. Gallinat. We weren't at that time made aware that there was a new zoning ordinance being developed. Over the last year, I've been working I went back and forth with the assessor's office multiple times to find out the process for merging our parcels. We finally got through that process this past spring. So, it's just, we really were trying to do the right thing. And I think we got caught up in a situation where originally we had hoped to get the construction done last fall of 2020. We encountered a lot of issues related to the pandemic with just trying to get quotes from all the different, from excavators, from builders. The stay at home, stay safe really created a lot of issues. And not to mention increased costs in materials. And we weren't able to get the project done in 2020. In hindsight, if we had applied for the permit, we would have been just fine and probably could have gone ahead with the project as envisioned. But we went out of our way to hire a reputable licensed contractor to try and somebody that we knew was going to apply for all the appropriate permits. He applied for the permits, once we knew we were going to be able to do the construction this spring or summer. And that's when we learned that the new ordinance had passed and now our planned project didn't meet the requirements. What am I missing here?
Well, and unfortunately, the builder went ahead and procured materials
Yeah.
before procuring the permit, and that was not our doing.
Yeah.
And so when we learned that the permit had changed, we already had
$40,000 into the project and we are not able to modify those materials or return them. So if we can't build as it is, it starts to get really weird. We have to use the same trusses. So it becomes a square building. It would have to shorten, which would then nullify any of the warranties on sort of the pre-built.
The siding,
of
the
it.
metal siding, if we had to go with a shorter building, we would have to cut the siding down, which would increase our labor costs, and I pretty certain would nullify our warranty and make it prone to rust. And so that's a concern. And so we would be left with that issue and a narrow, either a really
Square.
narrow building or a really square building, and neither of which would really meet our intended needs. So
We did spend 3 months basically trying to connect with, they had just sold the land behind us. We tried to
Yeah.
see if we could buy another half acre of the land. Ultimately, that ended up as a no, but that was the only thing within our control that we could do in
Yeah.
the scenario. We have asked the builder like to even just break down costs to see, is there a way, how can we not lose quite $40,000 on the project? And that's the issue.
Okay. Anyone from the board have a specific question for the applicant at this time? If not, I would like to review kind of as a board here, we'll open the discussion internally. If someone comes up with another question for the applicants, we'll loop them back in for those questions. But at this time, I would like to ask for someone to begin a discussion. If you have an opinion for approval or denial, we would want to remember that we need to start that with a motion, and then we would look for a second. That doesn't mean that we're going down the path of an approval or denial right out of the gate. It just means we're opening that discussion formally with a motion, and then we would begin picking apart the discussion on that topic. And then we could either continue to vote on that motion or we could withdraw that motion. So we've gone through that a lot, but I felt like it was important to kind of remind everyone of that process. We would have a chance for open discussion here and then move towards a motion. So does anyone on the board have a specific starting point that they want to discuss at this time? Ryan?
Yeah, I mean, I guess I do. And, this is certainly a difficult situation to try to reconcile, because I can certainly feel for the applicants' concerns about the money that they've spent and the investment they've made in it, as well as the delay that's occurred from having to wait through a pandemic and with builders in short supply. I apologize if it looks like I'm looking away. I'm actually looking at a second screen here when I'm reading stuff. At the same time, I'm on the planning commission, and I understand, we've sat through conversations. We understand why this change was made, some of the rationale for why it was made, and it was not made overnight. And I'm curious as to, why a builder would purchase materials without securing a permit in the first place, and where the responsibility lies. Now, whether there's a recourse for the applicant to deal with a builder in that regard, I don't know if there's a recourse or not, but it seems to me that sometime between 2019 and 2021, if permits are being pulled, that it would be incumbent upon a builder to understand the code before they actually pull the permit. Well, understand the code and pull a permit before they actually purchase the materials is what I would say.
Just a quick note, Andy appears to have dropped out of our meeting for a moment. So Liz, while he's not with us, you are
Oh man,
temporarily the chair.
On.
I suspect he'll be back soon, but
Well, let's hope, because I'm certainly not prepared to fill his big shoes.
I mean, I can continue. I mean, I can say that it's my opinion that as unfortunate as this is for the applicant, the zoning board of appeals isn't empowered with the right, in my mind, to make a decision to issue a variance on something simply because of an applicant's ignorance of changes in our code. I don't think that that's a defensible stance that the Board of Appeals can take. I think that if that is, and bearing in mind that if we do that, then we essentially have nullified the ordinance that was created by the Planning Commission in the first place. And I don't think it's defensible. And I don't think that it's something that we can arbitrarily do. I mean, it would be, I don't even know if it would change the conversation if it was a case of applying for a permit one day and the ordinance changed the day before. It's when that ordinance has changed, it's incumbent upon the applicant and whatever builder they're working with to ensure that they have a full understanding of what the ordinance is and what is expected of them. It's not a case of wanting to try to help, wanting to try to mitigate expenses to somebody, because as much as I would like to, I'd love to be able to do it. I don't think it's a defensible position for the Zoning Board of Appeals to be able to say that ignorance was a justifiable reason to issue a variance and change the ordinance within the township. So I guess I would say, I feel like our hands are tied. I don't think we have any real ability to do so.
So Rodney, is what Ryan is saying, is that accurate? Like the zoning board of appeals doesn't have the ability to make a motion to approve this, to grant them the variance? I thought that's why the zoning board was here, is if they thought it was legitimate to grant someone a variance, we could do that, where Ryan is saying that he doesn't think that we have that ability to do that. Could you clarify that for me?
Well, I will say this, that you have the criteria in your ordinance that are, the items 1 through 4 that are your guiding force here. I suspect that what Brian meant was that essentially it doesn't seem to rise up to this level. Now, again, this is your decision, and it's a collective decision of the Board of Appeals. But ultimately, you need to always aim your actions at whether or not the applicant has demonstrated that they meet these criteria that are in your ordinance. And if you find that they don't meet the criteria, then a denial of the variance would certainly be appropriate. If you find that they do meet the criteria, then you certainly have the option to grant either the variance they've asked for or some lesser variance. But the question always comes down to, do they meet the criteria or not?
Just to clarify quick on what I meant by that. What I mean by that is, whether we're on the Zoning Board of Appeals, whether we're on the Planning Commission, we have to make defensible decisions, something that would hold up under scrutiny in court. I don't see how the applicant has come here and admitted that they were not aware of the change, and that the materials were purchased ahead of a permit, and that they did not check the code before proceeding. I mean, I'm not sure how that's a defensible position for the Board of Appeals to modify ordinance because of that.
I apologize here. I had lost my connection, so I'm back now. I gathered that was kind of a recap of your initial comment, Ryan. I understand where you're coming from there. And Brandon, to echo your sentiments, we do have that ability to decide approval or denial, as Rodney mentioned. We just need to determine, again, like Ryan mentioned, is the approval or denial defensible? And part of that is to establish some response to those 4 criteria that we use to determine an approval or denial for any application. I think we have a good summary of the conditions. We've got a general opinion from Ryan. Does anyone else have any comments or opinions? Liz, Judy, Brandon?
Do we want to kind of go through each of the four, or, I mean, I
That would
think,
be a great idea. Go through it so the applicant can, you know, hear our reasoning if one or more of them meet or not meet the criteria. I think
Yeah.
that would be.
Rodney, would you mind helping us with that exercise and running through items 1 through 4 on page 35?
I'd just read each one.
If you could, please.
35 or 37, what page?
It starts on 35 of the packet.
Okay,
I think you're looking at 37 on a computer version there, Brandon, because it's coming up
yes,
with a couple cover sheets from
okay,
Zoom.
perfect.
So it'd be 35 of the packet itself, beginning after
Gotcha.
the agenda.
Yeah, it's the
Thank you.
start in our report. It's the start of the table, and each of the standards is in the black
Box.
border. So the first standard is strict compliance with restrictions governing area, setback, frontage, height, bulk, density, or other non-use matters will unreasonably prevent the owner from using the property for a permitted purpose or will render ordinance conformity unnecessarily burdensome.
So when we look at that, we have a response to that section 7.5C3 doesn't prohibit the applicant from having a detached accessory building to use for accessory residential storage. The applicant hasn't indicated any reason related to the land that would prevent the construction or use of an accessory building that fully conforms to the standards of this section. So that criteria has to do a lot with the site conditions, really is how we're looking at that. So as we move through that item, if anyone has an aha moment where they say they believe that particular item can be addressed with a certain comment or an interpretation, I'd like to hear that. You can raise your hand or just speak up. So as we look at that, is there something that's happening there from a perspective of the setback, the frontage, the height, the bulk, the density, or other non-use matters that would unreasonably prevent the owner from using the property for that agricultural accessory building use? So in past meetings, we looked at that and said that's kind of it's a yes or no. Do we believe that what's happening here is a condition that's being imposed that would prevent them from using it for that purpose? Not specifically the size that they're asking for or the height that they're asking for, but for that purpose. And I don't think it does. As we move on, unless somebody else has additional comment, I've moved to item 2. Rodney can read that first statement, and then we can pick up again with item 2.
Item 2, the variance will do substantial justice to the applicant as well as to other property owners.
The applicant has cited other detached accessory buildings within reasonable distance from their property as having similar size and height as the one they have applied to build. However, all of these buildings were constructed before the zoning ordinance 2006 took effect. In addition, not all of the parcels that previously built accessory buildings sit on are 2 acres like the applicant's property. The parcels range in size from 1 to 10 acres. This is precisely one of the factors for development of the current regulations, which is that 1, 2, 6, or 10 acre agricultural properties should be given the same requirements with respect to the accessory buildings. Any changes to existing accessory buildings will be regulated under this section, and any new accessory buildings in the future on ag would also be limited under this section. We have a staff opinion there that this wouldn't be consistent to provide justice to both the applicant and other property owners. So a common misconception is that because it exists, a condition like this exists by other applicants or other members of the community or property owners, that it should be allowable. Unfortunately, their precedence is not justification for an approval or denial. So we need to look at this specific variance on its own. And so is there substantial justice to the applicant as well as to other property owners? That would be the question that we're asked to answer in item 2. Does anyone have any specific opinions about that? I think half of that statement is easily answered, that it would very much do substantial justice to the applicant to help aid in their situation. Although we're not able, unfortunately, as a zoning board of appeals, we're not able to consider financial hardship as means for an approval or denial. So we're looking at it just on simple facts of timing of permits and applications and criteria that we're asked to abide by. So is there any other comments specifically related to item 2? If not, Rodney, can you read item 3 for us, please?
Item 3 is a lesser variance than requested will not give substantial relief to the applicant and or be consistent with justice to the other property owners.
For the applicant, a lesser variance would not work since the trusses for this accessory building have already been made. A modified accessory building for the applicant would result in occurring additional cost. So a lesser variance wouldn't be consistent with justice to other property owners. So previously built accessory buildings were regulated under the previous ordinance. So changes to these or newly built accessory buildings would also be subject to these same requirements that are coming into question tonight. So if we believe that this section needs to be reviewed by the Planning Commission for a possible amendment, we could make that request to the Planning Commission. But that's not going to help in tonight's decision. So we need to look at how we answer that question of a lesser variance that would be requested will not give substantial relief to the applicant or be consistent with justice to other property owners. I don't think a lesser variance is really going to aid in this circumstance. Does anyone disagree? Rodney, do you want to move on to the next item, please?
Item number 4 is the problem and resulting need for the variance has not been self-created by the applicant and or the applicant's predecessors.
The applicant contacted the zoning administrator and asked about applicable zoning regulations in 2019 and provided the requested information about the zoning ordinance standards in effect at that time. No action related to a building permit was taken in 2019. The applicant did not check back with the zoning administrator the following year to ask about any changes to the zoning requirements and did not submit a building permit application for the project. The applicant also chose not to contact the township in 2021 until the building permit application was applied for June 3rd, 2021. The work on a new zoning ordinance formally began in December of 2018 with a diagnostic report presented to the township from the project consultant. The new zoning ordinance would not be finished and take effect until September 2020. During the years of 19 and 20, it was common practice for the zoning administrator to inform residents and developers that the township was working on a new ordinance. That seems to be a sticking point here. The applicant mentioned that they weren't made aware of that. Yeah, and they're raising their hand, I think, to confirm that I just said that. They indicated that in their opening statement. Unfortunately, we have no way to confirm or deny that. They're saying that they were not made aware of it. I think because they weren't in contact about that specific question, I suspect it didn't come up. But they're raising their hand. Rodney, can you unmute the applicant for me, please?
Will do.
I think this might be a relevant point. We actually were sent to the assessor's office, and we were in contact throughout 2020 and into 2021 multiple times trying to get a hold of someone. That there was very big difficulty in getting a person because of COVID-19.
Right.
It's not like we dropped off the face of the earth and then came back on. It's like the whole world dropped off the face of the earth for much of that 9-month period. So there wasn't the normal flow of information or accessibility that we would have had during that. We aren't irresponsible people. We do double check things very well. And so that was the whole point of us initiating the permitting process and going through things. It was we had been in constant conversations with the township. I do believe they were not with Peter Gallinat. And I think that might be where there's probably a better understanding of who's who within that office, and we were under the impression that we didn't cease contact. We were constantly working this through during that time.
Thank you. As we've all had, I'm not going to continue to read all through that. I wanted to get to that point because I thought it was important to mention that there was a difference of opinion between the applicant about whether or not they had been made aware of that particular fact of the zoning ordinance change. I think it's clear that they've been doing due diligence, attempting to follow through on this execution of this project. So as we look at this, I'm gonna jump ahead a little bit. So the staff has offered an opinion relative to this item that the need for a variance is directly the result of the applicant's actions and choices, and not connected to any physical condition or limitation associated with the land, the lot configurations, or related factors. So again, that's a staff opinion, so I'm looking for board comment. Does anyone have any specific opinions about this? I'm encouraging open discussion by the board before I make a comment. I don't want to overstep here and offer my opinion without hearing everyone else's first. Liz, Brandon, Judy.
Well, I'll say I'd be disappointed if I were the Monfils and their contractor, that he wasn't doing more to make sure the permit would be approved before. I think, you know, a lot of the blame lays on that contractor for going ahead with things without having the permit pulled. Most responsible contractors would do that.
Any other comments?
I think it's, you know, it is so tricky because with COVID, there was so much shut down and open and closed. And so for the new ordinance to have taken effect in September of 2020, when everything shut down in March of 2020, like I get it. It is really unfortunate timing from some very obviously well-intentioned people. I really wish there was more concretely that I felt like we could do in that, you know, with COVID, you know, being a big part of it, but I'm not sure that I'm seeing it.
Yeah, I feel bad for the applicant, and I wish there's something that we could do that it was black and white, but yeah, it's a bad situation.
Yeah, I mean, I think unfortunately the pulling the permit would have been before purchasing materials, probably would have been the one step that could have happened. But I also know builders, and I know that that's just not always the case if they were operating on good faith, that they knew what they were buying. So I don't think you guys intentionally did anything wrong or a misstep. Again, I think it was really just an unfortunate timing alignment here. But our hands are bound by these kind of outlined parameters here. So
I echo many of the sentiments mentioned by other board members. I'm leaning initially, after reviewing all the information, my initial thought was similar to what Liz just mentioned. We do have items that we're bound by, but I do feel like the issue at hand here is less about having trusses already purchased and trying to make sure we help them fit into that box, and more about, I think, had this not been happening in the year with COVID-19 being front and center, I think a more conventional means of communication would have existed. I think an opportunity for maybe some in-house meetings could have taken place, and maybe some of this would have been addressed earlier on. So I think that there's a chance that these discussions could have happened, but whether or not the trusses were purchased prior to or not, I don't think that's our issue at hand here. I'm looking at the idea that was actions taken by the applicant right, wrong, and different. I don't know, but what we're saying, are we giving substantial justice to the applicant? And I think for me, the answer would be yes. And the criteria would be related to the circumstances surrounding COVID-19, which I think in today's day and age is a very defensible position. That's my personal opinion. Again, having less to do with the fact that trusses are already purchased or that financial implications will arise, and more to do with the difficulty or trouble with a normal application process throughout the pandemic, which I would say is evidenced in part by all the other items we've all lived through in the last year, but we haven't met since March 3rd, in part because we don't have applicant coming in, but we're not even meeting in person. Usually we would get together and meet, but we've been canceling meetings left and right. So I'm leaning more that route. But I see we've got a hand up from Ryan. You've got a comment. Rodney's got a hand up, and so does the applicant. So let's start. I don't know who was first, but Ryan, do you have something to add to that?
Yeah, I guess my concern, I guess, or a counterpoint to your concern about the COVID conditions, is that the applicant has said that they were in regular contact with the township. It's just that they were in contact with the assessor's office, and I'm not sure what rationale the applicant would have to be speaking to an assessor about current building code. Whether or not the assessor, I don't know what questions they were asking about, assessment, taxation.
Well, I think you mentioned they were talking about the parcel split and trying to join the parcels together so that they would be able to be in conformance. So I think they were aware of their circumstance.
Sure. But that doesn't, the COVID does not absolve them of the responsibility of dealing with each department that they need to deal with. And talking to the assessor in terms of joining property and parcels is certainly an appropriate thing to do, but talking to somebody that is dealing with zoning ordinance and dealing with current code is also the appropriate person to talk to as well. So having spoken to one does not absolve them from not having spoken to the other.
Okay, Rodney, do you have something you want to try and interject here?
I just I wanted to give some background related to the COVID shutdown. It's absolutely true that the COVID shutdown period had an impact on the township's operations for a period of time. So I just want to kind of give you the quick version of that. The township offices shut down in mid-March as the COVID shutdowns at the state level took hold and the health orders took hold. We during the time between mid-March and early May, staff was continuing to check our voicemail. We were returning calls and where it was possible, checking email. That was not always possible. For example, Peter Gallonay, our zoning administrator, didn't have full access to his email, but we were checking voicemail messages and responding to them during that period of time. The building and zoning functions of the township reopened on May 7th. That was the day that the state of Michigan let the building contractors loose, and we had a flood of building permits and other applications. So our building services and Peter Gallonay were in the office beginning May 7th. From then forward, the full township hall reopened in mid-June. But even before that, as the township was staffed beginning of May 7th. We did have a change in our assessor in 2020. Our former assessor retired. She announced her retirement just as COVID was hitting, but she actually was with us until through the end of June. We did have a new assessor start, and that's Ed Vandervries, who became our assessor of record July the 1st. I just was actually going back through my old emails and verifying that he was with us beginning in early July, both having staffing office hours and also handling things remotely. The contact information was available on our website for for the assessor. The office phone number did not change, but we did also have other contact information on the website, the assessor. But and the same thing with Peter Gallané, our zoning administrator. His, you know, even though the building was shut down from March to May, when Peter returned to the office, he was checking his voicemails, and certainly even if an email would have been sent, he would have responded to it when he returned after May the 7th. So that's the scope of the shutdown period. And even during that period, we were providing services as best we could.
Rodney, can you clarify that you're talking the years that you're talking about, March to May of 2020?
I apologize. Absolutely. Yes, it was March to May of last year, 2020.
Thank you.
The applicant has raised their hand for quite some time now. I am interested to hear what they have to say, but we've already heard from them. So I'm going to ask them to be brief in their interjection here. And then I would like to move to a motion on this particular item. So Rodney, if you could unmute the applicant, please.
If they are unmuted.
Yeah, just a couple of really quick things with regard to the comments regarding our contractor. I completely, agree with that, and we've had some pretty tough conversations with him. I do know that he was highly motivated to get materials ordered because the cost of steel and treated lumber was going through the roof. So maybe that swayed his decision making. Just to follow up on some of the other comments, we were in contact with the assessor's office because the only limitation that I was aware of, based on my view of the ordinance at the time when I downloaded it, was the limitation that I had to merge our properties. I made numerous phone calls and emails to the previous assessor with no response. It wasn't until the new assessor got in, after multiple phone calls and emails, that I finally got that resolved. So I think the point that my wife made was that we were making a lot of effort to try and do everything correctly, when we see all the time when people just do stuff without even trying to get a permit, without even downloading the ordinance. So we just like to see some dispensation for the fact that we were trying to do everything correctly, and I'll leave it at that.
Also, another element of the COVID issue is not just affecting one thing, which was contacting your office, but was affecting our ability to even get a contractor. So we're sort of juggling, okay, we want to get all the appropriate things together. We can't get a hold of the person. We were leaving countless messages. There's a lot of home phone numbers used. When we got that one resolved and we went through that process, we're having trouble getting contractors to call us back. And so this all was a process where every week we were making 1 or 2 calls, different people, waiting and trying to be patient. We weren't thinking at this point, okay, we better go back and find out if there's been some change from what we had been told before, because everything was at a standstill. And I do think that understanding the complexity of everything in the world, it wasn't whether the office was in fact working at some stage. There were a lot of competing things, and we were trying to work within all of that.
Thank you. Does anyone have a motion that they would like to make at this time? And reminder, we need to cite, we need to reference the specific variance request number, and then the details of your motion for approval or denial. And I want to refer you to our draft motion included in our packet prepared by the staff. We have it listed on page 38 for a motion to approve, and then page 39 is a draft for denial. Those two draft motions really outline the form that we need to follow, and then we could get a second on a motion and then wrap up some discussion. Is anyone prepared to make a motion?
I'm prepared to make a motion.
A motion from Ryan.
And I will say ahead of that motion that I certainly do feel for the applicant. Unfortunately, I do feel as though our hands are tied. So I would like to make a motion to deny PBAR 2101 application from Michael and Anna Monfils for a variance of 228 square feet and 1 foot variance of height. Section 7.5 point C.3 of the zoning ordinance for an accessory building on an agricultural zoning district parcel up to 2.49 acres at 5633 South Grant Road in the southeast corner of Section 35 PID 14-03-5-40-004-14 after review of the variance criteria in Section 14.4.b.4 of the zoning ordinance, and finding that 1, granting the variance would only give justice to the applicant and not to the owners of other AG district parcels in the area. Number 2, the applicant has not indicated any reason related to the land that would prevent the construction or use of an accessory building that fully conforms to the standard of this section. Number 3, the applicant contacted the township about zoning standards in 2019, but waited to submit a building permit application until 2021. And number 4, the problem and resulting need for a variance are directly a result of the applicant's actions and choices and are not connected to any physical condition or limitation associated with the land.
We have a very well articulated motion from Ryan. Do we have a second?
I'll second that motion.
We have a motion from Ryan and a second from Liz. Do we have any further discussion by the board? I would like to interject something here as it was outlined in item 3 of our decision-making criteria, that if we believe that section 7.5C3 needs to be reviewed by the Planning Commission for an amendment, I think I would like to encourage the board to come back to that comment, and maybe we'll talk about that in a later part of the meeting, because I think that this is an example of something, as I mentioned, regardless of the sequence of how this project played out with all of the mitigating factors associated with it, and trusses being ordered prior to proper permits being secured and zoning verification made. I think this extra foot of height or square footage as it relates to the overall size of the lot, I think is something that needs to be investigated further. And I would like to encourage the Planning Commission to pick that up. So I just wanted to throw that out as we look at this motion. We've got a motion and a second. Is there any discussion from the rest of the board? Seeing no discussion, we'll go to a vote. All those in support of the motion to deny variance request 21-01, say aye.
Aye.
Any
Aye.
Opposed?
We have an opposed, and we have a 4-1 vote for denial. That would be motion to deny has been supported 4-1. We have some general housekeeping items associated with a denial of the application. Rodney, do you want to speak to that specific housekeeping item?
Hey, if I, Peter, would you speak to that item?
Yeah, so the record of ZBA decision final. A decision by the ZBA shall be considered final 21 days after the meeting at which the decision has been made, to the extent that decisions are requested or required to be in writing. The minutes of the ZBA meeting and decision as proposed under supervision of the secretary shall constitute the written decision.
So with that, as part of this, a letter will be sent that will include the text of the motion, and it'll be signed by the chair and the secretary. And so that will start the official time period that's in the ordinance for appeal of that decision. So that letter will be prepared and sent out soon after the meeting.
Thank you. Again, I think as a whole, the board sympathizes for the applicant. I would hope that you're able to find a resolution, and I'm sorry for the situation that you're in. That closes the public hearing for item PV AR 21-01 at 7:55. And we would move to Item 8, new business. Item B. This is PZA 2101 administrative appeal. An application to appeal the determination made by zoning administrator Peter Gallané from sections 12.2 general requirements and 12.4 for modifications to non-conforming uses or structures related to modifications to an existing legal non-conforming second dwelling on a lot 3813 South Lincoln Road, an approximately 2.23 acre rural residential district R1 parcel in the southwest quarter of section 21. That's the summary of the administrative appeal. We'd like an overview from staff. Rodney or Peter, can you take that for us?
I can take care of that. Everyone should have a copy of our report dated August 23rd. Just some background. I'm not going to read all the background information, but this is an interesting property. There were a number of residential buildings that were moved out of the city and into the township back at a time when Central Michigan University was greatly expanding. These two buildings that are on the property, 3811, 3813 South Lincoln, are among those that were moved. They were just picked up from one lot and moved to this property. During our research, because this particular property was up for an auction, we had many requests for information about it. So research that was done by Peter found that they were moved to the site about 1967. That's when a well was ordered by the county health department. That was our initial information on that timing. Our first township zoning ordinance dates back to 1971. We had interim ordinance slightly before that, but 71 is our significant date here. So these were legally established on the property, both dwellings. The principal single-family dwelling and the secondary dwelling in the back were established before our first ordinance was adopted that set a standard of only having one dwelling on a lot in 1971. These are this building that is the subject of this request is considered to be a legal non-conforming structure and a legal non-conforming residential use from a history perspective. This is an unusual case. It's not a variance request. It was noted it's an administrative appeal. We do have criteria in the ordinance for that. The criteria that you have before you, the 4 items, these are straight out of Michigan case law. These are not in the Michigan Zoning Enabling Act. These have been established through court precedent, and they were added to our ordinance in recognition of that long standing precedent. So you do have 4 criteria to consider in looking at and evaluating Peter's determination. You have a copy of his determination letter, which was dated July the 27th of 2021. We do have some comments under each of the 4 criteria. Just one quick comment that's not in the report related to criteria 3 and 4. Both of these reference decisions you need to make whether there was an error made by Peter in his determination, whether it was an error of finding a material fact or an error in the interpretation of the zoning ordinance. One thing we'll note is that a difference of opinion, if you simply disagree with, in terms of you have a different opinion about how Peter should have made a determination, that's not the same as finding that he made an error. It is a stricter standard, really, to determine that he actually erred in what he chose to do. So simply disagreeing with him is not really enough to meet the standard of item 3 or item 4. You really do need to find that he made an error in finding material fact or an error in his interpretation of the ordinance for those 2 criteria. With that in mind, you have all the documentation that was part of what Peter reviewed. You also have the zoning ordinance itself that provides some additional background information, including the definitions for single-family dwelling and accessory dwelling. If you need, I can pull those up on the screen as well. But you have everything that Peter had when he was reviewing this matter initially. If you have any questions, we're happy to answer them.
Do we have an applicant present for this item?
We do. I will move Mr. Nelson over. Give me just a
Do we
moment.
have any questions for staff before we open?
Apologies.
Just have a quick question. Oh, never mind.
I have a
Go ahead.
question. Go ahead, Liz, if you had a question.
My question was, I guess, what I read through all of this, so apologies if I did miss it. It was a lot of information, but what is the recommendation then as far as the building itself? Does it have to come down? What is, and that's not necessarily relevant here. I just am curious, honestly.
That's a good question. So you saw, I mean, the significant issue is that Mr. Nelson chose to do work on this building without a building permit. He, as we noted in our background information, we spoke to him before he purchased the building, as we did others that were interested in the auction. We spoke to him after he purchased the building. And each time we said, make sure you get a building permit and make sure you follow the restrictions. A legal non-conforming structure is provided significant protection under zoning. It's allowed to remain in place forever as long as it's not expanded or altered in a way that removes that protected status. In the same way, the legal non-conforming use of that small structure as a residence is also protected as long as it is not altered or expanded in a way that removes that protection. In this case, Mr. Nelson, unfortunately, did a significant amount of work without a building permit. As you've seen, he has a building permit application that's dated in June. It was not submitted until well into July. And it was really only submitted after the building official came to the site to take action related to the work being done without a permit. In this case, the front of the building, which let's call it, the building essentially is two parts. There's an original structure, and then there's a lean-to addition off the back. The lean-to addition, the original slope and height of that were too short to be considered as allowable for residential living area under our state construction code, the Michigan Residential Code. We did have an opportunity during that auction process for our building official at the time, John Lipchick, to go into the building, and he made that determination that lean-to back section was not habitable living space, that it could be used for storage, but it could not be used for additional living area. And it was because of the low height of that part. Mr. Nelson, unfortunately, rather than doing the repairs and basic maintenance that he said he was going to do and should have gotten a building permit for, he essentially reconstructed that rear addition. He took the roof entirely off, and as you can see in the pictures that were provided, he constructed a completely different roof, much steeper pitch. We believe that he also raised the height of the walls at the same time. But we don't have documentation. That just appears from the pictures that the walls may be slightly higher than they were originally. But certainly the steeper pitch on the roof alone raises the height of the interior and would create a circumstance where the interior would become, under our Michigan Residential Code, residential living area. The problem here is that would expand, it would increase the area occupied by the non-conforming use. And that's not allowed under ordinance. The ordinance specifically says you cannot increase a residential living area that's non-conforming to occupy more of the building or an additional area than what was there and legal at the time it was occupied or built originally. So what he did without permits created a problem for the building, in that it technically removes that non-conforming protected status. What we told Mr. Nelson when this was discovered and the stop work order was issued was that if he put back what was there, if he removed that roof line that he constructed that's illegal, and put back exactly what had been there before, we would kind of move forward from there and acknowledge that the problem had been resolved and the legal non-conforming use was still there. He would simply have to limit the use of that lean-to addition to storage, as he was told from the very beginning. So that's where we are, and quite frankly, we still stand by that if he corrects the problem, puts back what had been there, that we would proceed forward under that framework.
At this time, I'm going to open the public hearing.
Real quick, Andy, before we open the public hearing, I want a clarification on procedure here.
Okay.
It's typically our procedure in the planning commission would be to hear from the applicant, open public hearing. But then when we went into a conversation amongst the board itself, we keep that closed. Unless we have questions of the applicant, we keep that closed.
We do, and if I feel that I have questions I want to ask the applicant, I'll continue to do so. And then likewise would encourage the board to do that if they have questions that need to be answered as well. I think given the specificity of each individual case, we may have additional times that we would go back to an applicant.
Certainly would. I certainly have no concerns with going back to an applicant. To me, I think the difference would be whether or not we're allowing the applicant to interject or whether we're asking the applicant specific questions.
Perfect.
I don't want to create a situation where we're having a back and forth between the applicant while we're in the midst of, having our deliberations.
Yeah, we will, at this time, we're going to open the public hearing at 8:07. We will unmute the applicant. We'll hear briefly from Mr. Nelson, and then we will mute Mr. Nelson until such time anyone has a question for him, and then he can raise his hand in response to those questions. If we have them, we will unmute him at that time. Mr. Nelson, thanks for joining us.
Good evening. Am I good to start?
Yes.
Okay, I will try to keep this briefer than I originally intended since we have gone some length here. So I am Josh Nelson. My wife Rachel and I, we live at 5215 South Nottawa in Deerfield Township. And we purchased this property that is at subject here in April, I think. I am a licensed builder. We have 2 other rental properties in the city of Mount Pleasant. I have no employees. I do all the work myself that I'm allowed to do. And this property is our model. As part of our retirement, we buy terrible houses. We put a lot of money into them, make them very nice single family homes for rent. So I will skip some of what I had written to the current business here. And I would say that with respect to the Union Township staff, that the zoning determination that was given is not actually theirs to make because this structure became non-conforming, as Mr. Nanny said, when the zoning ordinance came into effect. And section 12.2E states, the zoning administrator shall be responsible for maintaining records of non-conforming uses and structures as accurately as is feasible. And to this date, the township has not provided record of the establishment of this property's nonconformity and the nature of its allowed use. I heard a lot of times that it's a non-conforming structure, it's non-conforming use, but was never given any information on what that non-conformity meant and what its allowed use was. But what we do know is that it was issued a rental certificate in 2012, indicating the township was aware of its structure and use and endorsed it as a separate single family residence. The township was also aware that 3813 Lincoln was separately occupied from 3811 when the foreclosure process was underway in 2020. The sheriff's office served paperwork separately to 3813 South Lincoln. So like I said, I had in my letter to the board, I would refer again to 12.2J that this is a structure for single family residential purposes. And as such, it may be enlarged or replaced with a similar structure of larger size if it doesn't create new nonconformities or increase the existing nonconformities with respect to setback and parking requirements. And I would say that my alterations created no new nonconformities and did not increase the extent of nonconformities with respect to setback or parking requirements. I would also point out that Mr. Nanny and Mr. Gallen have repeatedly pointed to section 12.4 and insisted that I've increased the nonconformity of the structure. But in the end of the introduction of section 12.4 states, except as permitted in this section. So I would say that the board's decision in this case is significant to us personally. I would estimate a gross revenue if this were a rental building over a 30-year mortgage in excess of $130,000. And that definitely played a role in our decision to purchase this building, purchase this property rather. And lastly, I would like to reiterate that the alterations I've made were simply to make the structure safer, protect the structural integrity, and align with current building codes and practices. And with that, I thank the board for their consideration of our appeal.
Thank you, Mr. Nelson. We will be muting the applicant at this time. We had opened our public hearing at 8:07, and at this time, I would like to hear discussion from the board relative to this administrative appeal. Again, as staff has indicated, we have a certain set of criteria that we're attempting to understand and acknowledge here when we're making this determination for or against this decision from staff. We have a question from Ryan.
I actually do have a question for the applicant. I'm just curious, as a licensed builder, what his rationale was for his motivation to proceed with making these alterations to the building when the zoning official had made the concerns aware, made him aware of that. And I guess knowing that being a licensed builder, he knows he has to have a permit. So I'm just curious as to what his rationale was, regardless of the outcome of this whole proceeding, why you would proceed without a permit, what that rationale might be.
Thank you for the question. So I would point out that we did get a demolition permit for the property. And during demolition of this portion of the structure is when I discovered that it was rotted and basically beyond normal repair. And that is when I made the determination during the demolition to just take it down and build new. I had specifically spoken about changing the northeast corner to a hip, which was acceptable. In previous conversations, I had talked about replacing the bedroom window with a window that meets egress. So it's not like the information I was given would indicate I wasn't allowed to change the building at all. But with regard to why I did not secure the building permit before I made this particular change, we were getting a lot of storms and I was just trying to dry the building in. And I submitted for the building permit application right after that roof was complete, and didn't actually see Mr. Summer with a stop work order until a couple days later, just to make that clarification on the timing there.
So just to clarify, Mr. Nelson, you are aware that you needed a permit. You're aware that you needed to get a building permit to proceed. Understandably, I understand that your rationale is that there was weather coming and you were trying to get it roughed in, but you understood that there was a difference between a demolition permit and a building permit.
Yes.
Okay, thank you.
Liz?
I guess I was a little curious by the comment that it was used as a rental property in 2012 and that it had, I guess that it had its own address. I'm not sure. I guess, and I don't know the answer to that, but does that distinction change that it was a legal non-conforming structure with legal non-conforming use? Was that then a violation in 2012? I just, that's the first I'd heard of that. So I'm just curious what that component of it is. Is that something the township was aware of?
I can certainly address that if you'd like.
Please do.
The back dwelling unit, the 3813 was part of our rental program for a period of time. Our rental program looks simply looking at properties that are used as rental residences, and it has a licensing process for those and a safety inspection process to verify that certain minimum standards are met for any residential rental in the township. That program does not necessarily look at is the property zoned properly for it. That license is only to confirm that yes, the property is a safe for use as a rental based on the minimum standards of our housing licensing ordinance. However, as I said, the recognition of the township is that this second dwelling was lawfully established on this property prior to our initial township zoning ordinance. So it did have a legal non-conforming status. I was not here in 2012. I can't speak to what evaluation took place at the time, but it was certainly recognized that there were two dwellings on this property. The front dwelling, the one that's at 3811, is a conforming single-family dwelling. It is the single-family dwelling on the lot. Our ordinance is very specific that says you can have one single-family dwelling per lot. And that front dwelling meets all the criteria, meets all the requirements, and it's fully conforming with as a single-family dwelling use. The back dwelling, the one that's the subject of our hearing, is not a single-family dwelling in the sense that Mr. Nelson is describing. It is essentially a legal non-conforming accessory dwelling unit. That means secondary, accessory, secondary to the principal dwelling on the same lot. There's not a way to make that activity legal under our current ordinance, but there is a definition for accessory dwelling unit in the ordinance. It references a second dwelling on the same lot as part of that definition. So this building is an accessory dwelling. That's how Mr. Galaney evaluated it. It is not a single family dwelling as would apply, the term would apply to the dwelling up front at 3811. So anyway, with that in mind, the rental inspection program licensed the ordinance, licensed the building as a rental, and would today as well. That was one of the discussions we had during the auction process, and we confirmed to everyone that evaluated that property, including Mr. Nelson. As we confirmed after we evaluated it and confirmed it was a legal non-conforming structure and legal non-conforming use, we confirmed that it could be rented and could be rented separately from the principal dwelling up front. So in that sense, it certainly could be part of the rental program today, and that's part of the reason Mr. Nelson bought it.
Okay, I'm going to interject a couple comments here, and then I would encourage anyone else who has comments from the board to do so as well. I feel as though we're looking at a lot of specific circumstances that exist here that don't aid us in making a decision. The fact that a building permit wasn't properly obtained in the correct order isn't in question for the administrative appeal. The fact that the property has been improved dramatically, I don't think is in question here. I mean, it's obviously an improvement to the space. Whether the space is habitable or not, that's a building code question, not a zoning board of appeals question. We're stuck with the fact that it is a legal non-conforming structure. Now, I've not seen any proof of, as the applicant mentioned, a specific record of non-conforming uses and structures, but it is safe to say that by us putting in writing here in this public meeting that we are clarifying that this is an existing legal non-conforming second dwelling. I don't think that's under dispute, despite the fact that there may not be a book of records indicating a list of such structures at the current time of our meeting. It's clearly identified as a legal non-conforming secondary dwelling unit at 3813. So I think our challenge here just to refocus us, is that we have to look at whether or not it's allowed to be changed as a secondary legal non-conforming dwelling. So we're looking at it from the standpoint of a administrative appeal to that decision. So I think we're hearing about a lot of other factors to this circumstance and this property, but I don't know that they're all speaking directly to the question at hand, which is this a legal non-conforming structure? Yes. And is it allowed to be modified in the way that it was? And my personal response to that is no, it's not. But I would encourage further board discussion. Ryan, do you have anything to add to that?
I guess just maybe a clarification, or at least my interpretation. My interpretation is that the applicant is saying that the board or the staff has not provided justification for why it's non-conforming in the first place. So I think my impression is that that's what the application is part of what they're contesting, is that whether or not it should even be considered non-conforming. I guess I am curious if Rodney, just for the sake of things, could expand on exactly why that's determined as non-conforming for our benefit as well as for the benefit of the applicant. But beyond that, I mean, yes, I would agree with you. I mean, in terms of whether or not this board is tasked with determining whether a non-conforming unit can be added upon, I think the ordinance is pretty clear on that. I think that, I mean, that's plain language in terms of improving, making a substantial improvement to a non-conforming use. So to me, I think the direct point is to the applicant's point, and correct me if I'm wrong, but I think they're questioning whether or not it's even non-conforming. And he's shaking his head, so maybe that's not the case.
So I think if I understood Mr. Nelson, that he's basically was indicating that to the error, I think as he said, was that Mr. Galladay did not find that this was a legal non-conforming single family dwelling. Our ordinance, we have what I call a mortgage clause in our non-conformities section, section 12 of the ordinance. When a single family dwelling, your home, assuming you live in a detached single family home, if your home was a legal non-conforming structure or in that it was too close to a property line, it was encroaching into a setback or something like that, or if it was a legal non-conforming use in that the property is actually zoned commercial or industrial or something, but it was legally established as a residence. If anytime you have a non-conforming single family dwelling, it can be very difficult to get a mortgage, and it can sometimes be very difficult to get insurance. And so we have additional protections built into section 12 that apply to the principal dwelling on a lot, that single family dwelling, the main dwelling on the property. So in this case, for this particular lot, that's the building. If the building up front at 3811 South Lincoln, if that was non-conforming, then it would apply to that one. And those protections are designed to give mortgage companies and insurance companies assurance that their investment is protected. And so, for example, if let's say your house was legally non-conforming in some way, and a tornado came through and destroyed it. Under the provisions that we have in our ordinance, that house could be rebuilt, even if it was destroyed almost completely. I mean, quite frankly, if it was taken down to the foundation, it could be rebuilt on the property. And that protection is in there so that mortgage companies are willing to give a mortgage to that site. And so insurance companies are willing to insure that property, because both of those entities want to make sure that ultimately that their investments are protected. That status does not apply to this second dwelling on the lot. Whether we call it an accessory dwelling unit, whether we call it a secondary dwelling, it is a second dwelling on the lot. It is not a single family dwelling as defined in the ordinance, which is the principal dwelling on the property. And so Mr. Nelson is incorrect, and as Peter Galladay noted in his July 27th determination, that those additional protections essentially that would allow for some expansion or some alteration or replacement if destroyed don't apply to this building. This building is under the stricter standards that apply to other non-conforming uses and other non-conforming structures.
I don't want to monopolize the time. I want other people to be able to speak up too. I'm just, as a follow-up, Rodney, can you explain what makes the difference between the primary residence, which is non-conforming, versus the accessory? What designates one as an accessory residence versus one being as the primary single-family residence? I mean, you know what I mean?
Yeah. So, well, first of all, it has been the case since our initial zoning ordinance was adopted in 71, and still the case today, that you can't build a secondary or accessory residence on a property. There's no legal way to create what we have in this lot. Be that as it may, it was created, it was built that way in the city many, many decades ago and moved to this lot in, as I said, in 67. So we deal with it. What the difference really here, let's just compare these two buildings. The building 3811 meets the minimum square footage. We have a minimum square footage for a single family dwelling in the ordinance.
Mm-hmm.
It satisfies that. It meets all the criteria for a single family dwelling, and it is the principal building on the lot in that it is the main building there. It's the largest building on the lot. And it's recognized by our ordinance and the definition of the ordinance as being the principal dwelling or principal building on the property. In this case, the building that's the subject of this request at 3813, it does not meet the minimum floor area for a single family dwelling. It didn't meet it under the old ordinances either. So the standard the standard minimums simply were not satisfied. It is much smaller than a single family dwelling is required to be. And as I said, it holds a secondary position on the lot. It's to the rear. It's on the same property as the main building, but it holds a secondary position. So it is considered, if this was a garage, it would be just simply an accessory building or accessory structure on the back of the lot. In this case, it clearly is secondary to the main use of the property that is provided by that main building at 3811. So that's I think the gist of it really, that gets us the difference between principal and accessory.
And it sounds as though that's relative specifically to the size and the location on the lot.
Certainly predominantly, yes.
Okay. One of the things that jumps to my mind is in terms of building code, which again is not our lane here, so I want to be concise with my comment. We're talking about whether or not in a building code perspective, an improvements made to the property that would be of more than 50% of the value of that property, that would trigger additional requirements in a code that would trigger you to meeting new criteria, current codes versus maybe filing a permit under a rehab code. So that was one of the fleeting thoughts I had, was this is a small portion of this project, certainly smaller, I think, in total value than the main building in its totality. Unfortunately, I don't know that that's 100% relative to this question at hand. One of the other questions I would ask of staff is, would it be possible for Mr. Nelson to split his parcel into two separate parcels and then have two separate primary dwellings? And then at that point be allowed to expand this building to get it up to a habitable minimum square footage?
That question was brought up during that auction process, and that was reviewed by staff. And there was not found a way, just a number of scenarios that were looked at, there was not found a practical way to create two lots without requiring multiple variances for both lots. It would require encroachments into multiple yard setbacks. It would require variances from minimum lot frontage for certainly for one lot and possibly both. Yeah, it just simply was not practical because of the position of the main building on the property.
Thank you. Are there other questions or discussion topics from any of the other members? Does anyone have the interest in making a motion? I would like to move forward on this. And we could make a motion to, I guess I want to clarify, is I don't know that it's an approval or denial so much as it's a support of the administrative appeal or a denial. Rodney, can you help clarify that, please?
Well, what I would suggest, first of all, we do have the 4 criteria in our report. I would suggest, similar to what we do with the variances, to go through those 4 criteria. They've really, as was noted with the other case, it is kind of a yes or no question for each of the criteria. We do have the criteria from the ordinance in the black border at the top, and then down below we essentially set up a statement related specifically to Mr. Gallinet's determination that can be answered with a yes or no. And so I would suggest going through those 4 items.
Fair enough.
And then taking it from there to a potential motion.
Okay, thank you. Looking at page 68, section 14.4B2C, administrative review. The order, requirement, decision, or determination constituted an abuse of discretion. Written job descriptions have been established for each professional position in the township's community and economic development department. Peter Gallinet's work as zoning administrator is governed by the attached planning and zoning administrator job description, which outlines in detail his scope of professional responsibilities. To find that Mr. Gallinet committed an abuse of discretion in making his 7/27/21 determination, the Board of Appeals will need to make a determination that Peter Gallinet acted outside of the scope of his responsibilities described in the planning and zoning administrator job description and making his 7/27/2021 determination. It's a yes or no question. We've all had a chance to review the job description and the excuse me, the professional responsibility scope. I personally think it's safe to say that he is within his scope and responsibility of his job description to make this determination. I don't know if anyone feels differently.
I would agree with that.
I would concur.
Item 2, the order, requirement, decision, or determination was arbitrary or capricious. The following definitions are adapted from the Merriam-Webster Dictionary online application. Arbitrary, existing or coming about seemingly at random or by chance, based on or determined by individual preference or convenience and not fixed by law. Capricious, governed or characterized by a sudden, impulsive, and seemingly unmotivated notion or action, a sudden, usually unpredictable condition or disposition to do things impulsively. Peter Gallinet's action in making the 7/27/2021 determination was arbitrary or capricious. I think that's very clearly no, evidenced by the significant amount of background information provided and a long-standing commitment to his job. Item 3, the order, requirement, decision, or determination was based upon an erroneous finding of material fact. Staff has confirmed that the documentation included in the agenda packet for this meeting is the same as what the zoning administrator reviewed before making his determination. Peter Gallinet's 7/27/2021 determination was based upon an erroneous finding of material fact. Yes or no? I do not believe his decision was made based on upon erroneous finding of material fact. Any other discussion or comment as to that point?
I concur.
The order, requirement, decision, or determination was based upon an erroneous interpretation of the zoning ordinance. Each Board of Appeals member should have a copy of the adopted zoning ordinance number 20-06 for reference. Sections 12.2 and 12.4 from the ordinance are also included in the agenda packet. Peter Gallinet's 7/27/2021 determination was based upon an erroneous interpretation of the zoning ordinance. It's a yes or no question.
No.
I would agree. I don't believe he's made an erroneous interpretation of the zoning ordinance. I think this is a unique project. Certainly, the fact that we have limited cases of secondary dwellings of legal non-conforming structures is certainly unique in the township, and for obvious reasons, because this is quite a challenging circumstance. So having reviewed the information for our initial determinations, is there consent amongst a board member to create a motion and a subsequent second? And I'd refer you to looks like we're page 70 for draft motion for administrative appeal application. You'd be either making a motion to uphold the zoning administrator's actions or to not uphold the zoning administrator's actions, and the draft language is provided. Anyone interested in making a motion?
I'll make a motion. Motion to uphold in full the zoning administrator's July 27th, 2021 determination that that is the subject of this PZA 21-01 administrative appeal request from Joshua and Rachel Nelson for the second dwelling at 3813 South Lincoln Road, PID 14-021-30-010-00, finding that Mr. Galanet's action did not constitute an abuse of discretion, was not arbitrary or capricious, was not based upon an erroneous finding of material fact, and was not based upon an erroneous interpretation of the zoning ordinance.
We have a motion by Ryan. Do we have a second?
I'll second.
We have a motion and a second. Do we have any discussion? No additional discussion. We have a motion to uphold the zoning administrator's actions as detailed in the draft motion read by Ryan, supported by Liz. All those in favor say aye.
Aye.
Aye. All those opposed? Motion carries. Peter or Rodney, in this case, maybe since we're talking about Peter's decision, Rodney, can you read the details of the finding by the board for the applicant?
So you're talking about basically what happens next?
Yeah, just the recap of the decision so the applicant's aware of the timing of the formality of approval, or in this case, upholding of the decision.
Actually, in this case, as was said, the action by the Board of Appeals will be valid in 21 days. It will be noted in the minutes, and as I noted with the previous case, a letter will be prepared that will have a copy of the motion. And that letter will be signed by the chair and the secretary and will be sent to you as soon as it's available, which will be shortly after this meeting. And once that letter has been sent, that starts the clock for any appeal that you may choose to take on that. I will say, as was mentioned during the case, that the resolution of the roof, restoration of the original roof line and height, and establishment of that lean-to addition to a storage status rather than residential occupancy will allow the legal non-conforming protection to continue or be restored. And so, Mr. Nelson, I certainly would encourage you to contact our office to address that particular topic. It will require a building permit to do that work. And I would recommend that we move forward with that expeditiously so we can get that part resolved. I think that covers everything.
Thank you. We'll close the public hearing at 8:39 p.m. Moving on to item 9 on our agenda, other business. I do not have any other business. Peter, Rodney, or other members have other business. Moving on to item number 10, extended public comment. This would be a point in time where we would have 5 minutes for anyone choosing to speak at extended public comment regarding any issue on our agenda or otherwise in general. Open public comment at 8:40. extended public comment at 8:40.
As you were doing that, I moved Mr. Nelson back to attendee. So I just, he may not have heard everything that you said. So as you said, this is open public
Opening,
comment.
extended public comment for any item open to be discussed for up to 5 minutes. And that public comment, extended public comment, was open at 8:40 p.m. No takers on extended public comment. We'll close extended public comment also at 8:40 p.m. Final board comment. Does anyone have any final board comments for tonight?
I have one, I guess maybe it's a little bit of a curiosity for the sake of the board. Andy, I do appreciate the point that you made in our second agenda item here in regards to understanding the timeline in terms of permits being submitted or not submitted and that sort of thing. I guess I'm curious as to, and I guess maybe I'm just looking for feedback from other board members to see what their thoughts are on I guess my thought process, but sometimes I'd like to get clarification from an applicant like that in terms of their understanding of the actions we took versus the actions they took, because obviously these variances or an administrative appeal in this case are, they're motivated by the fact that there's a significant cost to them. And I don't think we would be having an administrative appeal had there been a permit that was issued or that was sought out prior. I think that he probably would have renovated based on the requirements of the permit issued.
Ryan, I want to interject something here. I don't want to cut you off, but I don't want to talk about specifics. I think we've closed that particular agenda item, so I don't know that we want to openly discuss something specific to one of those agenda items. So I want to be mindful of that, that we're not talking about something specific since we've already closed that item.
Okay, I guess and I guess if that's a determination, that's fine. I was just trying to clarify whether or not it was appropriate in our deliberations to establish awareness with applicants in that sense.
Yeah, I would tend to agree. I think that's a reasonable understanding. I think that helps us understand their perspective in general, to know what an applicant's perspective was moving forward, whether they were aware of something that would be required of them or not aware. I think it speaks to maybe how they chose to act. I think that's a valid point, and I think it's a good question.
Okay. Yeah, I'm not trying to rehash anything
Yep.
with any one applicant. Just I don't want to take us down roads that we don't need to go down. If that's an inappropriate course of conversation, I guess.
I think it does speak to the frame of mind of an applicant and what actions they may have taken based on their understanding of things. So I think that's within reason to help frame kind of how we get to this point, right? We're taking staff positions to understand how staff is viewing these actions, and we hear the background on how they arrived at those decisions. So I think it is to a point useful to know where the applicant's frame of mind was leading up to some of those decisions. So I think it's within reason.
Okay. Thank you.
Any other final board comments? Seeing none, director comments. Rodney, do you have anything that you would like to comment on?
I'd just like to thank you. I know this is challenging when you're not meeting regularly to jump in and take on these very challenging cases and consider them. I deeply appreciate the thoughtful discussion, and I certainly appreciate upholding Mr. Gallinet's action tonight. That was a kind of unique request. These don't come up very often at all. But overall, I deeply appreciate your participation tonight and your thoughtfulness. It is key to your success as a Board of Appeals. And so excellent work tonight. Thank you.
Okay, we will adjourn tonight's meeting at 8:44 p.m. Thanks, everybody, and we will see you next time.
Thanks.
Thanks.
Good night.
Right.